who had two different reports and also have categories for each relating to different illnesses, including not going deep into his credentials, even though he misrepresented his connections to Harvard. We shortened our cross-examination with Dr. Kirkpatrick, and even when our case began, we cut down several designations of Bonnie Rice in order to make sure we had enough time. Instead of resting when the court was looking at them to rest, they continued to call witnesses that we believe to be extraneous in real relation to this case. And at the end of their case before resting, a relative of the Kowalskis who testified through a Polish language translator. They made their additional time to both sides. The prejudice to the defense is
Okay. Now y'all should be able to see it now. Text me if you can't. Okay.
Just for everyone's planning purpose. So each of those 3 days that I know of right now will have to end right before noon.
Your Honor,
We're talking about exhibits, right?
yes, but before we do exhibits, the defense would like to move for reconsideration of the court's ruling yesterday allotting 4 additional hours to each side. The basis of the motion is the prejudice that's going to result in the defense. And to lay this out, the defense has respected what this court's admonition has been for the weeks leading up to trial, that each side was going to have 55 hours that would include direct cross and report. The court made it very clear to both parties, in fairness to this court, that that was also going to include a division of jury questions. And to the great credit of this court gave the shot clock every single day to both sides about where we were so there would be no surprises. The defense, in reliance on that, did their best. We did our best to give expedited cross-examinations, including a relatively brief cross-examination of Dr. Duncan, who had 4 reports with underlying assessments, a relatively briefer cross-examination of the economist who had multiple reports, a relatively brief cross-examination of Dr. Bifolco, who had 2 different reports and also had categories for each relating to different illnesses that I intentionally expedited to save ourselves time on direct for the witnesses we needed. We cut down our cross-examination of Dr. Chopra, including not going deep into his credentials, even though he misrepresented his connections to Harvard. We shortened our cross-examination of Dr. Kirkpatrick, and even when our case began, we cut down several designations of Bonnie Rice in order to make sure we had enough time. The plaintiff was well aware of the shot clock, and instead of resting when the court was looking at them to rest, they continued to call witnesses that we believe to be extraneous to their case, including multiple people from the church, Facebook friends with no real relation to this case, and at the end of their case before resting, a relative of the Kowalskis who testified through a Polish language translator. They made their strategic decisions on the order, and only after they rested did they ask for additional time. While we appreciate that the court allotted additional time to both sides, the prejudice to the defense is we cannot go back and recreate cross. The net effect of this is the plaintiff has 4 additional hours to cross-examine witnesses that the defense doesn't have. And due to that prejudice, we would ask the court to reconsider its ruling and go back to the 55 hours per side. Thank you.
The court's going to deny the reconsideration. Certainly, the court has been. You can sit down now. I think it's appropriate at this time. I hear what you're saying. If you wish to call Dr. Duncan and some of these other folks to ask them additional questions, you are free to do it because you also got an additional 4 hours defense. So, I don't see it as any sort of prejudice. I think it's appropriate given the length of time of those jury questions, and that's my decision. What's next?
And Your Honor, just briefly, because I do need to perfect the record on this.
You've already spent 5 minutes talking on this issue, and the whole point of coming early was to talk about exhibits.
I'll merely note that we have to move for mistrial as at the time decisions are rendered, so the defense moves for a mistrial on that basis.
You're moving for a mistrial. I just want to make sure I'm understanding. You're moving for a mistrial when you got additional time and you can call the same witnesses to address whatever issues. Is that what you're saying?
Yes, Your Honor, because
Can we go to exhibits, please?
Yes.
Thank you.
Judge, we really want to get some medical records into evidence. We have not received any specific additional objections. We just gave the court our There's no exhibits listed. They're the ones we've been trying to get. So we would like to start with 3032,
3032.
Lori Children's Hospital records.
And what's the objection?
Before this, Judge, you may recall, just on the motion for curative or
Can we
otherwise.
stick with exhibits? Like I said yesterday, I need to trim our sails. We need to stay on topic. Exhibits.
I understand, Judge. This is designed to do exactly what you told us to do Tuesday morning. You ask us, because of the difficulty of all of these individual piecemealing objections to hearsay within hearsay and experts that are not experts, we put together a curative instruction. And it's not even really that, it's 301.5 evidence admitted for limited purpose. And the purpose was, we don't have to get into that. They can move these things in wholesale as long as there's an instruction so that the jury does not take a doctor or a nurse who may have random comments in the record and attribute to them as though they were experts on the topic. And I don't know if the court had a chance to review it or not. I have a copy of it here.
I don't know what you're talking about.
Judge,
May I approach?
Judge, they filed this late last night. We haven't filed a written response, but we want some overall arching curative instruction as opposed to doing what the court asked them to do, which was to identify which pages and sections of this record they object to.
So this was filed last night. I honestly don't think I've seen this. This hasn't been docketed yet. I wouldn't give that, no.
Okay. So Judge, we've received no specific, we need to move the Lurie Children's Hospital record then.
What's the objection?
Hearsay contains unqualified expert opinion, quasi-expert opinion. I think and hearsay, mostly hearsay within hearsay.
Is there,
Those comments may contain therein that are not for medical treatment.
the other day, you said that you had a list of documents that you were concerned about. Is there something specific, or is it just this generalized statement?
Judge, I think we were hoping to have some form of generalized objection based on that, or a curative instruction that would limit our only concerns, and then we wouldn't have to go through all of these. It's impossible over the course of the evening to go through every single one of them. We understand the court's position on this, and we'll accept the court's ruling wherever it is.
The court's going to let in the medical records from Lurie's, which is 3032. Is that pages 1 through 249? Is that the complete?
It is, my understanding, it's the complete record, Your Honor, 3032.
What's next?
3047 Tampa General Hospital 7/30/15 admission.
And that's 1 through 1,148.
That's correct.
Anything specific about this, or just a generalized statement that you just made with respect to Lurie's?
In particular, the comment that Bonnie Rice contained within where she was, we can go through it, but we need 24 hours. If it could be admitted with the proviso that we'd be able to come back, and we understand that we over our objection of hearsay within hearsay and unqualified expert opinion, or opinion preparing to be expert, then what we could do is come back, because there are a number of, quote, opinions by Bonnie Rice, who's not a medical doctor, and they're not to reach medical probability, nor could they.
I delayed from Tuesday when this issue was addressed to give you time, so I'm not going to further delay. So court will go ahead and receive 3047, the entirety, which apparently is going through 1,448.
Thank you. Going back to the first page, Judge. 3023 Arnold Hospital admission.
And is this the complete set?
That's my understanding.
Mr. Whitney, are you taking this one?
Yes, Your Honor. We do have specific objections within this record for hearsay within the record and 403. I can point the court to the pages. The first is at 3023-0003. If we can put it up. What do you want?
Just need to turn it on. The screens are off. Let me cycle it again, but it's over to his feed.
Yeah, here, yeah, it's on. Thank you. 3032.
3023 and then
23.
page,
Sorry.
I'm sorry.
3023, page 3.
Thank you.
If you could highlight the history of present illness and pull that out so it's larger, please.
Smile, you go.
Your Honor, within this entry here, about 3/4 of the way down, the line begins, the pediatric intensive care unit because part of her home pain regimen consists of ketamine infusion. Our objection to this record is that this theme is throughout the Arnold Palmer record. This mistake, this inaccuracy. There was never a home pain regimen consisting of ketamine infusions. So with respect to this sentence, we would just redact home. It's true that her pain regimen consisted of ketamine infusions, but other than the resident and Arnold Palmer that got this wrong, there's no evidence in the record that these ketamine infusions ever occurred at the Kowalski home.
Yes.
So it would be highly prejudicial to allow these records in and allow them to carry this theme forward.
We have evidence in the notes, the personal notes that Mr. Kowalski authenticated on the stand where Mrs. Kowalski wrote she was giving IV ketamine at home through the report. We intend to admit that record. We have the doctor that will come and testify either by video or live to these notes. We also have evidence in Dr. Hanna's records that he had Mrs. Kowalski sign a contract to not put ketamine IV through the port. So these are absolutely, this is not a one-off. This is part of a theme that is part of the defense's theme. They were certainly welcome to call this witness across.
Who is going to testify that there was actually ketamine infusions at home? Who is going to testify?
Dr. Brandon Alexander.
And
And who?
Dr. Brandon Alexander is the resident I'm referring to, that Arnold Palmer, who had this one interaction and put this down in his record. He has no basis.
as a general statement, the question of ketamine infusion at home has been something that's been percolating for years, and every single time I try to get actual direct testimony, it always seems to be a hearsay basis for it. So unless and until there's actually someone that comes and testifies, I am thinking I've got a 403 issue because
Well, Judge, we can then hold this back for now, this exhibit, and after the testimony to come in, revisit.
but unless I get somebody who's going to come in and says this,
Okay, we
the
understand, Judge.
reference to home ketamine infusions is not coming in.
We will not ask that this particular exhibit be admitted at this time.
What's that?
We would like to put in 3001 and maybe we should start with 3002 since they're related. 3002, the consent for,
I thought the consent was already in.
no, Judge, I don't believe 3002 is in. The hospital records are in, but they wouldn't agree to this page of the hospital record.
This was marked separately.
This is just Mr. Kowalski's signature. I mean, what is,
This is the consent that they signed when they came into the hospital, Judge. It's part of the hospital records. plaintiffs would not agree to be part of the joint exhibit of the hospital records.
Well, I have no problem, and the consent's gonna come in, but where's the first page that I would normally would see, and why isn't this all together?
Well,
If we're talking about the consent, it's the paragraph that talks about diagnostic treatment.
Yeah, there it is.
On 4 pages.
it's on page 2, Judge. This is 4 pages.
Okay, so the first page is the signature page.
Can you go back to 1?
It's in reverse order, Judge, so it starts out, then it goes all the way down. Number 1 is the signature, would be the last page. Sorry for butting here.
Okay, so 3002 is the full record.
No, it goes to 4. But yes, it's the full record. It's 4 pages.
Can I see 3 and 4, please?
It's because, and the reason it's backwards, Judge, is because the hospital, that's how they do the hospital records. They come in.
So correct, you're telling me 3002, page 2 is in.
Correct.
So what's the objection to pages 1, 3, and 4?
This has to do with the release and the stretching of something that has absolutely nothing to do with our issues, which are the photographs and the 48 hours separation.
This is Mr. Kowalski's signature on
It is
an
correct.
admission document.
I believe so.
This is relevant, it's coming in. So the court will receive the totality of 3002.
Your Honor, please note we would like at some point argument on the terms of this agreement, because those would be within the purview of the court as the construction of the contract and its applicability to these circumstances, given the fact that they're not medical
Jansen.
records.
And I think I've said, if you're asking for an instruction as to the contract, that seems like a jury instruction, and your side can ask for a special jury instruction on it.
I understand.
3001.
What is this?
It's the notice of privacy practice referenced in the 10.7.16 consent.
And
It's 4 pages.
can I see pages 2 through 4? Haven't we already seen this? It hasn't. I feel like this is already.
I don't know, Judge, they all look alike at this point. I don't recall this going in.
Is there any, I mean, anything from the plaintiffs on this one?
Well, Your Honor, we would just reserve on having an additional instruction here. The purpose of this, from the defense's point of view, is they believe this gives them carte blanche to bring in Sally Smith outside of any investigation, and so that's how they're going to try to use this. So we'll try to craft an instruction.
Was this document given to your client?
The signature on the page would indicate it was on the previous exhibit.
It's relevant, it's coming in. Court receives 3001, which I understand is just pages 1 through 4.
3027 Elmhurst Memorial Hospital records.
What were the dates of admission or service?
2013 to 2014.
This is before the Kowalskis moved to Florida?
Yes.
So our objection would be relevance.
And this is before the CRPS,
Diagnosis.
well, definitely before the diagnosis, but before the first instance of CRPS?
More than a year before, year and a half before.
What is this for?
1 second here.
Sure.
Your Honor, these are related to the asthma and prednisone that's been referenced throughout this trial.
Well, there's really no dispute over prednisone. I mean, Johns Hopkins All Children's Hospital administered prednisone and prescribed prednisone. So it really it doesn't bear any issue in this case.
Judge, it has to do with her medical history, including her asthma, which has been an issue in the case.
Well, do these records say she did not have asthma?
That's my knowledge.
So we're putting in documents to further confirm the asthma that no one's disputing?
Judge, we'll pass on this one for now. We'll come back. 3028. This is a record from Dr. Hannah, dated 10/5/2016.
Yeah, I'm having trouble reading it.
Okay. He's a nutritionist consult that he has referred her for 2 days before our admission.
It says, nutrition consult needed due to patient being malnourished, is that the word?
Yes, sir. It's a firm.
So
And
body
so
weight.
this was
iron
2 days
deficiency.
before the admission
Yes, sir.
plan?
403, they did not know about this. It wasn't a basis for any of their opinion. It's a hearsay, and until such time as Dr. Hannah, who they had recently subpoenaed, and I guess we're planning to call Monday, testifies as to the context of this, it gives the jury complete misrepresentation. For the record, the record shows that Maya Kowalski was in Johns Hopkins All Children's Hospital on October 1st because she was again dehydrated based on the fact she was having a relapse and she had the stomach issues, which the diagnosis is part of CRPS. And then this is the day before, 2 days before she comes back to Johns Hopkins. This, taken out of context, they purports to show that she was somehow being abused because she wasn't being given enough nutrition. That is a completely, obviously from the record the court has seen, false premise given the testimony of her and everyone else. So as to 403, we object as to hearsay, but more importantly, 403 out of context until such time as Dr. Hannah, who they just subpoenaed to appear Monday, can talk about this.
Sure. Do I need to say anything, Judge?
No,
Thank you.
of course, receiving it. What's next?
3031, Dr. Mendez's records.
Give me a time frame that we're talking about.
He's testifying, Your Honor, November 2015.
October through December of 2015.
Oh, thank you. October to December 2015, and Dr. Mendez will be testifying.
So this is around the time of Maya Kowalski's trip to Mexico.
That's correct, Your Honor. Yeah, I just believe so.
Plaintiffs?
This alone is the only page.
Apparently,
Right. Document other than a quote diagnosis or even that. Dr. Mendez is the one who met briefly with the Kowalskis and then came up with the Munchausen as a possibility. That's not, and so we moved to exclude any quote opinion by Dr. Mendez contained within there. But the document itself, we don't have a problem with. We are just moving to exclude and redact anything having to do with a quote diagnosis. He had completely no qualifications whatsoever to make that.
that would seem like we can cross-examine him on.
Well, the problem is if it's taken out of context, Your Honor, then it would be, I think, a 403 issue. And so until such time as there was sufficient record, predicate in the record for the court to determine whether or not the jury should be seeing random comments by physicians who may or may not have liked to be out of Kowalski and may or may not have any possible qualifications to throw these things out.
Let me ask the defense this. I have been excluding Chapter 39 matters
Yes.
at the defense's request. Why does this not go to a Chapter 39 issue? Because we're not, what does this go to? What cause of action does this go or defend against?
Mr. Shapiro's going to respond. That's all right, John.
Yes, Your Honor. This goes to confirm he's an independent treating provider that noticed irregularities between the relationship between the mother and suspecting whether this was actually CRPS or some other underlying psychological factors. That's been a very important theme for the defense to be able to say that all children saw inconsistencies and irregularities in their record. So did other providers as well. It doesn't go to Chapter 39. It goes to exactly to confirm that a lot of what all children saw was also the same. And there's an allegation in this case for medical malpractice, mistreatment, and the plaintiff saying, you know, you got this diagnosis wrong in the record, you mistreated her in the record. So this is a prior physician that made a very similar or same observation and diagnosis.
But assume for the sake of argument it goes to medical malpractice. How does that help the jury as to what Johns Hopkins Children's Hospital should have done or did do with respect to treating Maya Kowalski?
Well, if the court is going to exclude the plaintiff from alleging that the diagnosis of Munchausen by proxy is medical malpractice, then perhaps this doesn't come in. But if the court is going to allow the plaintiff to insinuate or argue, as I believe they've argued repeatedly, that this diagnosis of Munchausen that was on the Morris transfer is so far out of left field and you came up with this and this was wrong, you have no support for this. We have another physician who a year earlier made a very similar or same observation / diagnosis. So it goes to that exact issue. Now, if the court is going to say, I'm not going to allow this jury to consider any of the diagnoses made at all children's as part of the medical malpractice claim, then we could possibly reconsider this. But at this point, the jury's heard this. They've heard that the Kowalskis were floored by this. This came out of left field. And here we have a doctor, an independent physician, making the same observations and diagnosis. So it goes directly and as a defense to the claims that the Kowalskis have raised in their case in chief.
Is this document for purposes of today?
Pardon me.
I think I'm going to need to think about this more. I mean, obviously, there's been discussion of Munchausen and by proxy as well, but I'm still trying to wrap my head around the concept of, sure, the All Children's was aware of that as a possibility, but how does that talk to us about what All Children's Hospital should have done or did do as far as its treatment of Maya Kowalski? I mean, because from a 30,000 foot view, can a medical provider say, oh, well, look, there in this record from somebody else a year or two ago has this thing, therefore I don't have to do, I don't have to provide treatment for the patient in front of me that I've got my hands on right then and there.
That's not the argument, Your Honor. The standard of care defined under Florida law is what a reasonable healthcare provider would do under same or similar circumstances. So the plaintiff has introduced to this jury that part of the big defense to the reason for not consenting to the transfer is this diagnosis code that came out of nowhere. Part of the defense of that is for us to be able to tell the jury that this diagnosis that they say was the impediment was out of left field. They're saying it's out of left field. It's not part of the standard of care. For us to be able to tell the jury what would a same or similar reasonably prudent healthcare provider do, we absolutely need to be able to say same or similar healthcare physicians now in Naples, in Tampa General, at Lurie Children's made the same observations.
I feel you're misconstruing what I've heard. Maybe I misheard. I heard the plaintiff say that they did not want to sign documents that had that diagnosis on it. And they felt that there might have even been criminal liability if they were to sign a document. So they're basically making a declaration against their own interest, which is different than what you just argued.
Right, but
So did I misunderstand the plaintiff's position?
respectfully, I think they have said that, but they've also said to this jury that that diagnosis was incorrect. They're implying to this jury that that diagnosis came out of left field, that it wasn't made in good faith. And if Dr. Newberger specifically said in his testimony that that was an incorrect diagnosis to the prejudice of the family. This goes directly to observations. That's our entire theme of the case, that there were other providers at the time raising these red flags and making diagnoses and observations that were exactly similar to this one.
I think I need more time on it, and I think we need to perhaps a memo on this one.
Okay, and I'll just one other thing while your Honor is considering it. This also goes to the issue with Dr. Wassenauer. This diagnosis, suspicion of Munchausen by proxy, went back to Dr. Wassenauer as a letter to him raising this, and part of the direct and cross-examination of Dr. Wassenauer was, did you see this in the record? What did you do to intervene on this point? What did you advise the Kowalskis? It also goes to their awareness as a potential in the record of somebody else telling the Kowalskis, we suspect there's a psychological factor. Perhaps you don't need to go to Mexico. Perhaps this is not a course of treatment that is being recommended. So it's an incredibly important note to the defense for a number of different reasons.
What's next?
Okay, Judge, it's not on the list, but I'd like to revisit the exhibit, and we could put it up, 31980001. The court sustained the hearsay objection to this document. It has to do with Charlotte LaPorte being the one on the call. So my response to the hearsay is that this is a document that the witness was essentially accused of not being truthful about this and making it up. This is a prior consistent statement consistent with the testimony offered to rebut an express or implied charge against the declarative improper influence, motive, or recent fabrication. She specifically states in the third paragraph, yesterday when you were on the phone, I had to redirect you. And that is a prior consistent statement, therefore it's not hearsay.
Your Honor, I think the previous discussion is being misrepresented. I think if you zoom out again, you see at the bottom of the page, this is the exhibit that continued with Beata Kowalski's email, if I'm not mistaken, if we go to page 2.
Well, that's correct, Judge, but
And that was the problem, is that we pointed out that this continued and there was previous exchanges that were relevant.
And this is the one where I basically said it's all coming in, or
Exactly. And they withdrew it. There was no.
well, okay. I think that was a different one we withdrew, Judge, but.
well, it was a different number, but it was the complete
Well, that,
email exchange.
but Judge, the purpose of putting this in is not to put in all of the conversation. It's to put in the prior consistent statement. The rest of the email will delete all about, everything else. It's about yesterday when you were on the phone, I had to redirect you as a prior consistent statement due to, and we believe we have the right to put it in, it's not hearsay, because of all the attacks on Ms. LaPorte, whether or not she was the voice on the phone.
I'm going to stick with our discussion, the comments I had 2 days ago or whatever it was.
One other comment, Judge, please, briefly. If you do consider it hearsay, it's not being offered to prove the truth of the matter asserted, but that she was present. And I believe that is an acceptable exception. We're proving that she was present on the call.
That's truth. That's fact.
I will put the,
Yeah.
I will put the whole thing in, Judge, if that's the issue.
We object. At this point, she's gone. We can't cross-examine Michelle Laporte on Ms. Laporte on this email.
And she was released.
And it's a prior inconsistent statement. If they will take a position that this proves she was on that phone call, she says here, I did not give my authorization to record a phone call. She did not object at the time, so it suggests it wasn't her.
Judge,
It's hearsay any way you look at it.
I don't remember.
Judge, we'll
what
bring her
the-
back if that's the issue. So if they want to prosecute her.
So what's next?
I'm sorry, did you sustain it?
I didn't rule. I said, I thought you were gonna try to put the whole one in, and I don't remember the number, so until I can look at it. Because remember, there was like 4 pages of this email.
All right, we'll revisit it tomorrow, Judge. Okay. Moving on. We would like to put in 3033. These are dental records, Judge. The relevance is that these are procedures that Maya Kowalski went through subsequent, well, before and subsequent. I guess.
So the dates are from 2015 to when?
Well, definitely into 2016, Judge. I'd have to, can you go to the next page? 2017, next page, please. 2018.
So there's nothing before 2015, is that correct?
That's correct.
Objection relevance.
Overruled. Court will receive 3033. And it's pages 1 through 20. Is that the complete series?
That's my understanding.
I'm asking the clerk, because
Oh.
I want to make sure when I admit the whole document that there's not 85 pages and,
Oh, no, that's,
thank you. What's next?
same 3034, page, 15 pages, similar.
What dates are we talking about?
I believe these are all after. Can you go to the next page, please? 2022.
Anything besides relevance?
Nothing besides relevance. There's no
Okay,
dispute that she went to the dentist.
Hearsay.
Court's going to overrule the objection on 3034 for relevance and admit it.
3035, Nemours Children's Hospital Records.
Now, what dates are we talking about? Is this for the actual admission, or is this the attempted admission? Or is it both?
1 second here. We'll skip this one for now, Judge, and we'll come back.
What's next?
3037.
ENT.
They're 2016 records.
Besides relevance, is there anything?
Oral 3, hearsay.
Well, how is this a 403 issue?
Because it's an ENT, and there's no issues here regarding ear, nose, and throat. It's not, this is not for asthma, this is not for immunology. And it's darn sure not for the CRPS.
Well, it's during a CRPS episode, so it is relevant. I disagree on 403.
And I'm wondering,
It's
what
14
we
pages,
wonder with a lot of these, Judge, is the actual doctors at Johns Hopkins didn't have these documents. many of these at the time of admission and what was going on there. So how, if it's coming in to show their state of mind for treatment, how are things that they never knew at that time relevant?
You can always point out the absence of these from the Johns Hopkins if you feel that that's something that you need to argue to the jury, but this is a provider who saw Maya Kowalski during the CRPS issue. And so it's relevant. I don't see how there's a 403 issue. So unless you can point to me for some specific passage in here, it's coming in.
Probably isn't much to it, is there?
Well, there's 14 pages. We'll see now.
Is there diagnoses?
Can we scan the paper?
Yeah, I would like to just see what. Okay. That is. Next. 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 Benny. Is that it?
Next.
Next.
That's it.
It's hard to see at this point the relevance of Maya Kowalski and having this exam and procedure.
Okay, court's overruling the relevance. Court receives 3037, looks like it's pages 1 through 14.
3038.
What are the dates of these?
I believe 2015, 26. Oh, looks like 2016, 15 to November 2016.
Who's referencing this? I'm sorry.
Pediatric gastroenterology, hepatology, and nutrition of Florida. Let me go to the next page. She's in there for abdominal pain, constipation, RSD.
Next page.
Next page, please.
Next.
Next page.
Next page.
No mention that one.
Yeah, so it talks about ketamine, coma, you're okay now?
Of course.
Things like this, we've been spending a lot of time on the question of relevance of medical records of providers concurrent to the specific time frame. I'm just pointing it out that we spent a lot of time on that. The court receives 3038, pages 1 through 9.
All right, do you want to wait on the rest? Give them time or which?
let's do the one that's 11 pages, 3039, and then
Okay.
that'll probably be it. Next page. And next page. Next. What date is this? 2015. Okay, next. Next. Next.
It seemed to be duplicative, Your Honor. I mean, I think we just saw this in the previous record. That's, not sure why it's coming in twice.
It's a different facility, right?
I think this is the exact same procedure and the exact same page we saw before about she was brought in the operating room place.
I don't know if this was in the other, a lot of these doctors' records have got records from other doctors because they've been forwarded to them. I don't know if this specific one was in the previous one, Judge.
I think it's fine. Question, is it in the Johns Hopkins records? I don't know. We'll see. Court receives 3039, pages 1 through 11.
All right.
Okay. Anything else before we bring in this jury?
Just another schedule, Your Honor. Did I understand we're staying till 6 tomorrow night?
We're going to keep going through exhibits. Yeah. We're trimming our sales, and our days are going to get longer.
We have two issues, but I think they can wait till the next break.
And I highly encourage, since I'm telling you our days are going to get longer, that you all need to be better at communicating and not fighting every single issue. But if you want to, we will stay longer and longer. If we need to start coming in on Saturdays and Sundays, we're going to do that too. We're going to finish this case. Let's bring in the jury. Good morning. Please be seated. Were you able to enjoy that lovely weather yesterday? I'm glad. A little too cold for the beach, huh? Okay. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information about this case. Is that correct? And that you have not been approached by anyone about this case. Is that correct? And you've not seen any media accounts of this case. Is that correct? Mr. Hunter.
One quick question.
Madam Clerk, if you can swear in Dr. Michelle Smith.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
All right, Doctor.
Good morning.
Good morning.
Would you tell us your name, please, ma'am?
Michelle Smith.
And what is your occupation?
I'm a critical care physician at Johns Hopkins All Children's Hospital.
I'm sorry.
And this, we got a mic problem.
Can you hear me now?
Yes.
Sorry, I don't usually speak very loud. I'll do better.
Okay, there you go. You said you were employed at Johns Hopkins All Children's Hospital.
Yes.
And what is your job at Johns Hopkins All Children's Hospital?
I'm a critical care physician.
Now, the jury has heard a lot about Dr. Sally Smith, your Dr. Michelle Smith.
Correct.
What's the difference?
I'm a critical care physician, so I'm trained to provide care to children in an intensive care unit. And Dr. Sally Smith is a general pediatrician who also specializes in child abuse.
Okay. Now, would you give the jury the benefit of your background and training, please?
So I went to medical school at Georgetown University. I then did my general pediatric training at Children's Hospital of Los Angeles. I then went and did a pediatric critical care fellowship at Johns Hopkins Hospital in Baltimore.
Okay. And are you board certified?
I am board certified.
Okay. How long have you been at All Children's Hospital? And I'm going to ask you to break down its different iterations at All Children's and then Johns Hopkins All Children's.
Okay, so when I first started, it was All Children's Hospital, and I started in 2002. And I have been there since 2002 and went through the transition with the acquisition with Johns Hopkins Hospital in Baltimore.
And what is your primary role at Johns Hopkins All Children's Hospital today?
I'm a critical care physician.
Okay. Have you had occasion to contribute to the literature in your profession from time to time?
I have done mostly quality projects. I have presented at a conference most recently in Portugal on simulation use in the ICU for cardiac arrest.
Okay. And do you work purely in the so-called PICU?
I work both in the pediatric intensive care unit and in the cardiovascular intensive care unit.
Did there come a point in time at which you became involved in the care of Maya Kowalski?
Yes,
And when was that?
I believe the date was October 9th. It was a Monday. I took over the care on Monday.
Okay. And if that were to be October 10th,
Okay, it's 10th. Okay,
would that comport with your recollection?
I believe so. Yes, if
Okay.
that was Monday.
I'm going to ask our faithful tech folks to put up, did you bring your notes with you this
I
morning?
did not bring my notes with me.
You did not?
I did not.
Would you put up 1001-78?
Is it in there?
This is in evidence, Your Honor, as part of the All Children's Hospital record. And I'll ask you to put, it's not the page I was looking for. Go to the next page. There we go. Okay. Let me ask you to take a quick look at what's on the screen before you and tell us whether this is the note of your taking over the care of Maya Kowalski on Monday morning, October 10th, 2016.
I don't see anything.
Is that your note?
I don't see anything.
Oh. No.
Your screen's not, probably the power.
Yeah. let me try. See if it's nice. Hey, I need the mic.
Oops.
Maybe let's sign up.
There we go.
It's up. It's working now.
Okay.
Thank you.
Our assistant IT.
Man, many times.
One second. And Mike, if you're listening, don't be come right now.
Thank you, sir. So you came in that Monday morning, October 10th. Tell us a little bit about what your routine is when you take over a patient's care on a Monday morning like this.
Okay, so it's not unusual for us to start a service on a Monday. And so typically we would contact the physician who is on service prior to us, and we get sign out on all of our patients. So that usually would occur on a Sunday. So I spoke with Dr. Tepa on Sunday, and she would review all the patients that would be on my team the following day and review, the current plan of action and prepare me for taking over on Monday.
Okay. And was it your understanding this patient had been admitted over the weekend?
Correct.
And you were taking over from Dr. Tepa Sanchez?
Yes.
So when you took over, when you came in and saw the patient on Monday morning, what did you do? What did your routine consist of? And what did you do to assess this patient?
So our typical day starts with another handoff. So the person who's on call that evening in the hospital, the physician, provides a handoff to us. And so we meet and, again, get a handoff on all the patients in the ICU, what occurred overnight, so that then I have all the information from my handoff from Dr. Tepa. So what she may have not included in that handoff that she was unaware of. And then we would move from that to another huddle where we have a multidisciplinary huddle that involves our charge nurse, our respiratory therapist, both medical team physicians, residents, sometimes a social worker. And we kind of get a feel for what the ICU is like that day. It's kind of obtaining a shared mental model so that we know what patients in the unit are sick, who's going out of the unit, who will be discharged, what type of admissions we'll be getting. And it really just kind of brings us all together so that we're all aware of all of what's going on in the unit. It's a large ICU, and so it's important for all of us to know all of the, goings in and out of the unit.
Okay. In this particular case, what did you learn about Ms. Kowalski that morning?
Objection. Hearsay.
Did you take a history regarding Maya Kowalski that morning?
We would, my first interaction with her would have been on rounds. And so after we finish our huddle, then we start rounding and we go through all of the patients on our team. And during that, the nurse would also give us another update of any issues that came up overnight. And then we would present all of the current data, including vital signs, laboratory studies, or anything that would be available for us to review. And at that point in time, we would interact with the family. Now, and let me just clarify with referring to my note.
Is there a particular part of your note you need to refer to, Doctor?
I was just looking to see whether or not, where I discuss our discussions with the family.
Okay. Well, let me direct your attention to the paragraph at the bottom of the page you're looking at, 79. And it says social. Could I ask our support here to bring that paragraph up? And it continues over to the next page so you can see, you can refresh your recollection with what's there.
I remember that. So I did meet with the father. One of the pieces that was signed out to me by Dr. Teppa was the family's interest in potentially being transferred to Nemours Children's Hospital. And they had reached out to their ICU physicians over at Nemours about a transfer. And so I spoke to father and I told him that I would reach out to them. And I did speak to an ICU physician at Nemours who had reviewed the information that they had been provided over the weekend. They had discussed it with their pain team. And at that point in time, they did not feel like she was a candidate to be transferred to their hospital. That Dr. Santana, who is their pain specialist, felt that this was.
Objection, hearsay.
It's offered to prove the truth of the matter asserted, Your Honor. It's offered to prove what she was told. What did you learn, if anything, from Dr. Santana about what they wanted to do or not do at the time?
Objection, hearsay.
Your Honor, may we approach Karen?
So my they got her acting like something wrong with her. She want that money.
Had Dr. Teppa Sanchez attempted to begin the process of transferring this patient to Nemours the previous day, to your understanding?
Correct.
And on the morning of October 10th, did you attempt to continue the process of arranging transfer?
It probably would have been in the afternoon after we concluded rounds, but yes.
Okay. Did you have any discussions with the father beyond what you have told us about regarding transferring the patient to Nemours at that time?
In regards to transfer, my conversation would have been relaying what I learned
Objection,
when I
hearsay.
spoke.
With Mr. Kowalski?
Is it with Mr. Kowalski?
That's what I thought until I got interrupted.
I thought the question was Mr. Kowalski.
It was.
If it is,
You can continue.
I was told that the family wanted to be was interested in transfer to Nemours, so I spoke with Nemours, and then I went to Mr. Kowalski, who was present in the room, and I spoke to him about the potential transfer, and that at this point in time, she was not a candidate for transfer.
Did you have any conversations with Mrs. Kowalski, the mother?
The father had requested that I call Mrs. Kowalski, and I did call her and left her a message, but I did not speak to her that day.
Okay. On that Monday, what did the treatment plan for Maya Kowalski consist of?
So the treatment plan was brought together with our pain team. They were helping coordinate the care of the management of her pain infusions. And so if you could just please go back to the neurologic section. So Dr. Elliott was the pain team physician that was on that day. And so every day we met with him and we coordinated our care together and developed our plan. And then we discussed it with the family. And so that day we had discussed with the father the weaning plan for the ketamine and the dexmedetomidine infusions that she was on.
Okay. And did you conduct an examination of Maya Kowalski that day?
Yes.
And what were the results?
Everything, she that day did not really want to be examined. And so I was able to get some exam, but she, because of her discomfort, did not want a complete exam. So it was a limited exam, and it's documented in my note.
Let's go back for a moment to the transfer issue. What did you tell Mr. Kowalski about why the transfer was not being approved by Nemours at the time?
So as I documented in my note, Dr. Santana wanted to have her on an outpatient basis. Her treatment plan is an outpatient treatment plan, and that they really wanted us to wean her off of the medications. And then
Objection, motion strike. It's not correct.
Excuse me, I think it-
Sustained.
Instruction to the jury, please, Your Honor.
You'll disregard the comment as to what the doctor in Orlando allegedly said.
But let's continue. Can you recall any other interactions that you had with the Kowalskis on Monday, October 10th?
no,
And then did you also take care of Maya Kowalski on that Tuesday, October 11th?
yes,
Okay. And when did you arrive at the hospital that morning?
we typically arrive at 7:30 in the morning.
And did you conduct rounds that morning in much the same way you've described before?
Our day would be the same.
Okay. Did you have occasion on that Tuesday, October 11th, to speak with Mrs. Kowalski?
Yes.
And what did your conversation with Mrs. Kowalski consist of?
Mrs. Kowalski was concerned that the information was not appropriately provided to Nemours, and that there was potentially, the facts of Maya's history that were not provided. And so she really wanted to arrange a conversation with them so that she could tell Maya's story.
Okay. And were there some particular therapies that Mrs. Kowalski expressed to you that she wanted to obtain at Nemours?
Yes, she wanted an intrathecal infusion pump.
And what was after you had this discussion with Ms. Kowalski about her concerns, what did you do?
I then reached out to Nemours and spoke with the physicians there and organized a meeting with Dr. Santana and the ICU physician. I'm not sure what their name was.
Okay. And do you have a note of that date, October
Yes.
11th?
Yes.
And that would be, I believe, starting on page 100176. That's in evidence, Your Honor, as per the All Children's Hospital record. And I would direct attention to the last paragraph on that page that begins with, I contacted Nemours. And did you in fact contact Nemours and arrange for a telephone conference?
Yes.
And who was a party to that telephone conversation?
It was Dr. Santana and Dr. Torrey present and the bedside nurse. We met in the ICU physician office.
Okay. And before we go into those details about the conversation, tell the jury what an intrathecal
That's the daddy, y'all. Oh, y'all can't hear. Wait a minute. Hold on. Hold on for a minute. Hold on for a minute. Wait. Let me see. Why y'all can't hear? I can hear it. You can't hear them? I can hear. Hold on. Let me. Can I hear on my phone? Hold on. Wait a minute. Hold on for a minute. Hold on, because I can't hear it on my phone either. Hold on for a minute. Why has it got two strings up? I don't know what happened. Hold on. I don't know what happened. Let me see. Hold on. Let me see. All I want to finish getting this out the way. 2-7. I don't know.
Yeah, I'm wondering what we wonder what.
All I wanted to get the thing to see. I can hear it good on my end, but I can't hear it on mine. I can't hear it either on my well, you know what? I can stop right here. Hold on for a minute. Let me see. Oh, so we missed. Hold on.
Time we would interact with the family. Now,
Oh, it playing.
let me just clarify with referring to my note.
Hold on.
Is there a particular?
Hold on. It was on their end. Let me see something. No. So what we can do, we can discuss what. Let me stop it on this side right here, because it's good. We got to finish up. So what we're gonna do is react. We're gonna go ahead on. Hold on for a minute. So we can react to what we already done seen. Because you got to pay it. One thing about it. So we can react to what. Okay, we can react to what we just what's going on, y'all. Only thing only thing that I don't understand about this whole thing is Maya. Is she still playing like she have a problem, but they have it like she do have a diagnosis, something wrong with her. But I don't know. That's why we got to get into it. So what I do that next half when I get off of work. But that's her dad sitting in there. The mama made her sit that way. That's not her, but let me see. Hold on for a minute. Let me see something. Hold on for a minute. I don't know. It's something about this lady. What you think, Cher? What from what you don't listen to? What you think? What you think? From what you learned, do you really think something wrong with Maya? She was sitting in the courtroom. From what you heard, do you believe something wrong with her? I want to hear what y'all got to say. What you got to say? Shelley, what you got to say about what's going on? I want to hear what y'all got to say. Okay, y'all, I'm gonna stop right here. But I got to hear from you all. What do y'all think? Do y'all think What do y'all think about Mike? Right now she's 17. But this everything happened when she around about 8 or 9. Y'all tell me what y'all think in the chat, and I'll be back this afternoon when I get out from work. I need to hear what y'all think.